And joining me to discuss this further is a journalist, Tete Kofi. Good to have you join us at this hour. Now, let's get your reaction to this judgment by the English court granting Nigeria's application for an extension of time and relief from sanction. That's in a case against P&ID.
Well, literally, I mean, I was sitting here in London when the news came through, and I could hear the sigh of relief all the way from Abuja. On this judgment, and the judge used fairly strong terms. He said that a prima facie case for fraud had been established by the Nigerian government, and that justice would be served by giving the government enough time to stand the grounds of its disclosure. Now, this is not a green light. It doesn't mean that the Federal Republic is out of hot water yet, but it's a very, very strong amber light.
I know that you have been following this case for a while now. You said some of the things that were said by the judge, but what is the most striking for you when it comes to this judgment?
Well, what is striking for me is that it's going to set a benchmark on the activities of multi-million-dollar contracts, not just for Nigeria, but across the entire continent. As the story unfolded, it became clear, at least to those of us in the journalistic community, that something wasn't quite right about this. In the first place, it looked, from all the evidence gathered by journalists and so on, that this wasn't actually a bona fide contract. And it suggested, therefore, that the contract had been awarded under terms which weren't particularly, if you like the expression, kosher, meaning that there may have been some inside interest within Nigeria who facilitated this contract. Secondly, the other thing that made us all pause for thought was whether or not indeed there'd been bona fides in actually running this contract through, or whether or not the whole purpose of the enterprise was to benefit from Nigeria defaulting on the contract and then being sued, as it was successfully, for damages. Now, the other thing is that under English law, such damages are compensatory, they're not punitive. And with interest racking up at the rate, I think, of $1.3 million a day, in the first place, which country can afford that? In the second place, which African country can afford that, particularly in a post-COVID world? So I think that a lot of people thought that, this is a pause for thought, and this is going to give us an opportunity to really get down into the nits and the grits of this case.
So you mentioned, like you rightly noted, inside interest. We also saw the EFCC arrest a couple of people in the country who did plead guilty to playing a role in this whole situation. What lessons do you think that the country has to learn from this?
Well, it's a basic lesson about governance, in that whenever huge contracts of this nature are being negotiated, there has to be extra due diligence served on the parties who are acting as agents for in this case, the Federal Republic of Nigeria, in other cases for other government institutions, because these are eye-watering sums of money. And we just can't afford them in Africa to go missing, because we got roads to provide, we got hospitals to build, we got schools to build, we've got infrastructures to serve up and develop in the interest of our own citizens. So the issue is one of diligence.
Right. So according to the judge, this judgment was given due to the exceptional circumstances where the government has uncovered evidence of massive fraud in procuring the award. What options do you think are open to Nigeria at this time?
Well, to present cast iron evidence of the frauds that have taken place. I mean, when these sorts of things happen, they normally require an insider working within the client company, which in this case would be the Nigerian government, to facilitate and speed through without due checks without due diligence of the steps leading to the award of the contract. Now, that's the first lesson that's got to be learned, is how well those steps were taken. The second thing is that the Nigerian government is going to have to present fairly strong evidence that indeed Mr. Quinn, who was the chief principal in the company P&ID, actually did perjure himself, and suggesting that actually there wasn't any likelihood that the contract was going to run for the 20 years of its term, and that his motive was not to make profit from this contract by relying on the Nigerian government welching on its end of the contract.
So there are two sides to this judgment. There is the relief from sanctions, and there is also the extension of time limit, which means that the country can either move to arbitration or settle out of court. What do you expect the country to be doing at this time?
Well, that sort of thing depends entirely on the confidence of the country. If the country can serve up individuals who willfully defrauded the Republic of Nigeria by taking bribes to facilitate this contract, let it come forward. If the country can prove that Mr. Quinn or agents acting for Mr. Quinn did perjure themselves by providing false evidence, let the country come forward with that. I think this isn't just Nigeria's battle. Nigeria is one of the most powerful, if probably the most powerful African country. If Nigeria can be rolled over and blackmailed into a corner to make settlements when Nigeria and Nigerian people have done no wrong, it sends a bad signal to smaller, weaker African nations. I think Nigeria ought to play hardball on this one.
Tete Kofi, journalist in the UK, thanks for talking to us.
Pleasure.